Court TV legal correspondent Julia Jenaé, and you're with the defense team.
That's right. Matt, thanks for introducing the defense attorney who was standing here with me, Prya Murad, and your co-counsel, Prya Murad, who you both valiantly just really put on a defense for your client. It was a very difficult case, but walk me through right now, knowing that this jury has come back with this decision. What's just the reaction there at the defense table? I saw you hugging Tracy so tightly.
It's always heartbreaking. I think people forget this about criminal court, particularly when they're watching true crime or even court TV. I mean, you go from having a person who is free on earth to being completely incarcerated. So for Tracy, she went from having a husband that she has seen every day for her life, absent when he's, traveling for work, to someone who's sitting in a jail cell. And as a lawyer, as a defense lawyer, that happens, in our profession as well. And so it's always, it never gets easier.
Yeah, he seemed to be more prepared for it than she was. Was he prepared? I know you asked for him to be kept out on house arrest. Was he thinking that could be a possibility, or knew that today could have been his last day being able to go home?
I can't speak on his behalf. I can tell you that prior to any of my clients, anyone getting a verdict or doing a plea, we have a discussion about these are sort of the realm of options that could happen. So he was prepared in the sense that we told him best case and worst case.
And I know sorry, didn't mean to cut you off, right outside of the courthouse when this was over, there was a press conference. A lot of us were asking you questions. So some of these are repeats of that, but I appreciate you joining us here live. But I do want to ask about this decision not to take the stand. Do you regret that he didn't get to tell jurors his side of the story in light of the verdict?
So, look, it is the government's job to prove their case beyond a reasonable doubt. This idea that people should take the stand or need to take the stand and tell their story is really distant from what the Constitution requires. And so we made a decision based on our belief that at that time the evidence that the state presented was not sufficient. The jury, of course, took that and, came with the verdict that they did. But, after a guilty verdict, you go back and you think through everything, right? Your voir dire, could I have done this or that differently? But I do feel that we put on, absent some of the rulings, the best case that we could on behalf of Tim. And, we're going to be pursuing an appeal for him.
A lot of people were wondering about the 24 months that was offered by the prosecution at one point before this case, and of course now that he's facing 40 years at sentencing in November, wondering if he should have taken the deal. But you revealed something to me that people may not have known that was a condition of that 24 months.
So the plea deal that we were provided was 2 years followed by 5 years probation, contingent on Tracy either taking a plea or Tim doing a proffer against Tracy. I had asked the prosecution what the plea for Tracy would be, and we never knew it. It was kind of okay, if he's not interested, then, we're not going to negotiate on Tracy's end. So the decision that we made based on that, I think it's a little misleading to say that there was a clear plea deal in this case. It was made very last minute and close to trial. And, Tim wanted to tell through the trial his story as well. So that was a plea deal that we spoke about in great detail and that he rejected, as he has a right to do.
Was there a difference between them being severed and together when it comes to plea negotiations? Would that have impacted it at all?
I don't believe it did in this case. I think it can in other cases, but it did not in this case.
Let's talk about some of the things that the judge did not allow in this case. I know you mentioned that there will be an appeal in this case and that you may be trying to keep your client out of jail pending that appeal, but what are some of the strongest things that you feel you'll be putting in that appellate motion?
So we filed several motions in limine regarding the child's behavior prior to when he ran away on January 28th, 2022. We were cut off anything prior to the age of about 9 or 10. The court found that it was temporally irrelevant. Even after the state's expert, Wade Myers, said, there's nothing before the age of 10, we were not permitted to cross-examine on that despite asking. My expert, because, just given the rules of evidence, was not able to specifically speak about it. So we were very limited in what we could offer as far as the prior record. We also wanted to admit to show no malicious malicious intent, that there were actually adults since the removal that have had to take actions due to the fact that the behavior of the child was not improving. Again, it's not my intention to disparage the child, but these are in written pleadings that we believe that it was essential for the jury to hear this, because it shows that how other grown-ups, right, how other adults are acting towards him, which goes to this idea of intent. And it also, there is a level of hypocrisy here from the state that, we have taken a child from a situation into another situation that should be improving and better. The state's expert testified that if you take a child with an attachment disorder and remove them from that situation, you anticipate to see improvement. We asked if we could then discuss what was previously not permitted in evidence, and we were not allowed to do so.
And just to recap that, because I did think that was an interesting argument inside the court, I was a little bit surprised at the ruling that Dr. Myers said that, hey, if you take this child or someone who's suffering from RAD and they're in a better environment, then they should improve. And you all wanted to show that he may not have improved in the way that was suggested, but that was denied. Many things were denied in this case. Was that frustrating at a certain point? You had to deal with a barrage of objections over and over in this case.
The state has a right to make any objection that they feel is in good faith. So I'm never going to knock an attorney for doing what they think is right. I think that as defense attorneys, I've been doing this for many years now. We know there's always an implicit bias against the accused and their lawyers, regardless of whether people wish to admit that or not. This idea that people come in thinking this person is presumed innocent, no one does that. And so I think that unfortunately we see that in our courtrooms as well. And I think any defense attorney watching this can say that that is something that routinely happens in our trials. So of course I find it frustrating, but I am sorry to say that I am used to it. And as defense attorneys, we do what we can to put on our case with what we're able to present.
When it comes to sentencing, what's that going to look like from you all's end? Do you have people already that you're planning to call? And what do you think the judge will do?
I don't know what the judge will do. In the state of Florida, you have a guideline range, not quite like we have in our federal courts, but there's a score at the bottom and then a max, and the court has sort of that range. But the court can also do what's called a downward departure, and so we will of course be making every argument that we can to get Tim the lowest possible sentence.
And what is that range? It's from where to where?
Last time I checked, it's about prior to the child neglect being filed, which was done right before trial. He scored 35 months at the bottom up to the 40 years. And so that's about where the judge has the range. But again, the motion for downward departure allows the judge to depart under that range at the bottom.
Okay. Let's talk about that child neglect charge, because we were researching this case and then kind of scrambling at the last moment, realizing, wait a minute, this is different than the indictment. Do you know what prompted the child neglect charge to being added almost a year and a half after they filed the initial indictment and after the plea deal was turned down? Is that right?
It is after the plea deal was turned down. I don't know. Look, the state has the right to file what they want on the information. They have the right to add additional charges. I don't think it's appropriate necessarily to pile on, because as you pile on more charges, that possible sentence gets higher and higher, right? And so you're sort of leveraging against a person to try and, make them take a plea deal or not go to trial. And so as a defense attorney, that's very frustrating, because as you know, trials are dying because of trial taxes, because of mandatory minimums, because of guideline ranges that are really scaring people from fighting their cases, as they have a right to do.
Can you talk about this family at all? This is a case that has really torn them apart. We saw the Ferriter daughters in the courtroom for closings, just reminding us that it's not just RF that's at the center of this. There are other children who are right now no longer with their parents. Just what can you say from the defense and defense attorney standpoint?
I think this is an incredibly sad case, because I think regardless of what the verdict had been, an entire family has been completely torn apart. And regardless of what, the state has presented and what the jury has found, they did love these kids. And at this point, they went from a family of 4 who's going on, trips and going to Sedona and doing things together, to being completely, now Tracy's out of custody, Tim's in custody, the kids some of them are together, and I, can't really speak to that, but, some of the kids are separated, and it's like this entire process has completely destroyed this family. And the purpose, and I'm talking now about sort of more dependency cases, but the purpose of our dependency system is family reunification. And I said this before and I'll say it again. If we gave people resources, you have no safety net for people with a child with a mental health issue, and people don't know how to handle it. Particularly, I think it's becoming, more and more mainstream. But I think that in general, there's a lot of bad advice out there. There's a lack of resources, and you can't just walk into an inpatient facility. You have to get a referral. You have to go through this entire process. And so I think that it is a real failure of the system, a lot of systems, that we are unfortunately here today. And I don't think that Tim Ferriter being in custody or going to prison solves any of that.
Now, the prosecution, we spoke with them just a bit ago, and they said that parents need to seek professional medical help, that's the one piece of advice that they can give. Can you talk about what help the Ferriters did get in those 6 weeks, and if there was any kind of, I asked you this before, any kind of advice they got, not just professional, but any layperson that may have said this was a good idea?
No, I mean, I think it's very clear that the way in which, and this was part of the defense, that this was handled was not correct. No one offered this particular advice. Dr. Rappa did say there are practitioners, and paraprofessionals that have a more, a strict militaristic view of treatment, but she doesn't agree with that. And I'm not a professional, but I agree with her. So no, that's not the case. But this idea that they never sought the help is not true. The help is not easy to get for anybody with a mental health issue, including children and including parents of children. And when they came to Florida, they went to a pediatrician. This barely came out in evidence because we were only able to get into it a little bit with Dr. Rappa per the rulings. But there was an effort to ask for a psychiatrist. I mean, I think anybody knows you don't get, I can't get a doctor's appointment for 3 months out for my basic needs. So this idea that, there's just appointments available is not true. When they came in, they sought a psychiatrist. There was actually an incident at the school, and one of the teachers recommended them a psychiatrist, and they were waiting. They came in right before Christmas.
So they were still working on
it.
And Prya, we only have about 30 seconds
Okay.
left. Anything that you want to say before we do have to send it back to our studio in Atlanta? And thank you again for talking to us.
I just am devastated for Tim Ferriter, for Tracy, for the family, and we appreciate the jury for taking the time that they did. We wish that the verdict was different, and I wish that this family could be together. I don't think what happened today solves any problems.
Attorney Prya Murad, thank you so much.